Hi, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about, do beneficiary designations override my will or trust? So I'm going to share my screen with some thoughts. Um, the very short answer is yes, they do. So be careful and be aligned. Often clients come to us and they'd like to structure an estate plan, a will, or revocable living trust that has, for example, continuing trusts um, for children, for asset protection, et cetera. But when we look at the balance sheet, we see that on their financial accounts, they already have payable on death or transfer on death or beneficiary designations outright to various people, right? So, what would happen in that case if they were not the same? The beneficiary designation will always override the estate plan. So, no matter what the will or trust says, if there's already a POD/TOD on that account, the administrator or custodian of that account is going to pay it directly to the individual that is named. It is not their responsibility to go through um, how many umpteen, client estate plans or customer estate plans that they have in their banking platform. They're simply going to pay whoever you've designated. So it is very important to keep the beneficiary designations current, aligned, um, and coordinated, I'll say, right? Coordinated or possibly removed. So if you want to channel everything, for instance, to lifetime trust for children, for asset protection from divorce and all of that, you would have to undo the payable on death or transfer on death designation that you put on your big brokerage account so that it can flow through the estate plan to those trusts. So, there's pluses and minuses. I'm going to say the benefit of the plus, if you will, of these designations is simplicity and quick access after death. The negative, though, is that they don't account for a sequence or a scenario or trusts. So, an estate plan, right? A will or a trust can say all to, child A in trust, if not to child A's children in trust, and if none, meaning no one's left living, to child B, their sibling, right? That sequence in the trust that we create, that's done in an estate plan in a will or revocable living trust. That's not on a bank form, okay? A bank form is here's the money, goodbye. They get issued a check and goodbye, which is fine if child A is, doing all right and there's no creditor protection concerns and it's a small amount of money. But if we're talking millions of dollars, so larger dollars, a simple POD, TOD is really not going to cut it. And God forbid if, you know, child A is not living, who is the successor? Right? The estate plan really details out the entire sequence and accounts for underage beneficiaries and all sorts of scenarios. The successor in the case of a POD is unclear, or it may revert. It may, depending on the bank policy, revert to your estate, which then puts it into probate, which then could potentially open it for creditor claims. I don't know, final medical bills or anything else that we can't possibly know yet, for the simple reason that this wasn't thought through intentionally. So, what can you do? I would say that definitely have your estate plan align with your beneficiary designations by having a comprehensive consultation with an estate planning attorney to make sure everything lines up for your current and future planning, not the designation you made 15 or 20 years ago that may or may not have made sense back then, but no longer makes sense now. You have to rethink and realign it for going forward. So if you would like to learn more, you can go to our website at irinashea.com, click the Get Started tab, and there is no charge for our initial consultations. Thanks.